Good evening, friends. Having discussed legal history or the course of evolution of constitutional developments in India, if you recall, we began our journey with 1773 Regulating Act, then up to 1858, then thereafter up to 1947 Indian Independence Act. In the course of discussion, we focused mainly on Government of India Act 1919 and Government of India Act 1935, which provided for a federal polity in India for the first time. Then we discussed Indian Independence Act. Overall, I think history is complete. How from 1773 onwards up to 1858, how the administration of East India Company underwent increasing control by the British government, and 1858 onwards, British government assumed the charge of administration in India. We have discussed in detail. I hope things are very much clear. Now come to the next chapter, that is fundamental rights. Is a very important chapter from examination point of view, and in general also every citizen of India should know the fundamental rights, basic rights which he has been conferred with by the founding fathers of the constitution. One more thing that I would like to discuss here, that one of the important constituents of good governance in a democracy includes striking fine balance between the authority of state on the one hand and freedom of people on the other. It is here that fundamental rights come to play a very important role. If you remove fundamental rights, then your welfare state will become, or democratic state will become, a police state. Fundamental rights are designed to strike fine balance between the authority of the state, authority which is required to discharge responsibilities, and on the other hand, the necessity to ensure that this authority does not end up trampling over the basic rights of the people, or their freedom or their liberty. So we need to strike fine balance between the necessity to empower the state to control and regulate the things, and on the other hand, the necessity to give adequate space to the people, so that in individuals or group, to give adequate space for the expression of their likes, dislikes, preferences, their will, their aspiration, freedom, liberty. So this fine balance is required to be struck. Otherwise, no polity, no government can ever be stable and can ever be sustainable. So this is one of the defining characteristics of all balanced polities. All over the world, wherever you have democracy, you have this kind of arrangement. But things may differ from country to country because of historical factors, sociological factors, cultural, economic, and political factors, prevailing situations, circumstances, and the vision for the future. Lot many things are there. So before we begin on fundamental rights, first of all, we should be very clear regarding what exactly the right is. What is right? Adhikar ka matlab kya hota hai? So whenever we think of right, remember, whenever we think of right, I am not talking about the first word, human rights or natural rights, or for that matter, legal rights or constitutional rights. I am not talking about the first word. I am talking just about right. What is right? Adhikar kya hai? So whenever we think of right, we think of some kind of claim, some kind of claim over something, some kind of claim over something, some kind of entitlement, or some kind of position, anything. But by virtue of some legitimate disposition, मतलब आपका अधिकार किसी चीज पर, कोई इंटाइटलमेंट, लेकिन उस इंटाइटलमेंट का कोई बेस या कोई आधार होना चाहिए जो वैध हो. By virtue of being an employer, you have certain rights. By virtue of being an employee, you have certain rights, certain claim over something. By virtue of being son and daughter of somebody, you have certain rights. By virtue of being wife or husband, you have certain. By virtue of being a human being, you enjoy certain rights. Whenever we think of right, we think of some kind of claim that you can exercise. A claim that you can exercise by virtue of some disposition. There has to be some justifiable ground. There has to be some justifiable ground where from you can exercise claim over some kind of entitlement. This is known as right. There. Now come to human right. Human right. So human right would mean, by that means the human right would mean the claim that a person can exercise over something by virtue of the fact that he or she is a human being. Getting your point? The scope of human right is very broad, very broad. Human rights refer to the rights which are available to every individual on this planet. Every individual on this planet, irrespective of his caste, or class, race, or religion, ethnicity, your nationality, it has nothing to do with all those things. It means rights which are available to every individual on this planet by virtue of the fact that he is a human being. There is not a human right. So, scope of human right is very broad. So, scope of human right being broad or narrow has to do a lot with how society all over the world, different societies, the global community, how we are evolving in terms of our ethical, moral standards, in terms of values. It means a society which is progressively, or global society or global community, if progressively, we are evolving progressively, then obviously there will be a wider scope of rights. You will recognize everything that every human being has a right to be treated with fairness. Every human being has a right to be provided with food, shelter, and clothing. Every human being has a right to be given a space for the expression of his will, his opinion, his line of thinking, right against exploitation, a right to profess any religion or practice any religion, a right to seek remedy, lot many things. So their right to be treated equally, equality, right not to be subjected to any kind of discrimination, lot many things are there. So human rights, the scope of human rights has to do a lot with how the global community, societies, and different nations, how they are evolving. Particularly, the more progressive the evolution, the wider will be the scope of human rights. You will recognize all those things that every individual, every human being has a claim over something by virtue of the fact that he's a human being. Clear? Human rights. Now come to fundamental rights. Fundamental rights constitute that component of human right. Fundamental right is not separate. Fundamental rights constitute that component of human right which is so basic that in the absence of them, the moral, physical, intellectual growth of any person would be impossible. So fundamental rights constitute only a portion of human rights. But it constitutes that portion of human rights. It refers to those human rights which are so basic, so fundamental that in the absence of those rights, you can never think of multidimensional growth and development of any individual. You cannot think of a happy life, because how can a person be happy unless the person is provided with an opportunity to give expression to his individuality, give expression likes, dislikes, preferences, and that uniqueness associated with his individuality. Happiness is all about action. What kind of action? That provides for the expression of your unique capabilities, your instinct, likes, dislikes, preferences in a way and manner that it does not encroach upon the similar rights of others, but it gives you a lot of happiness, gives you a lot of space. It uninhibited expression of your like, dislike, preferences to your own happiness and to the happiness of the society, to make a positive contribution. So when we talk about fundamental rights constitute that portion of human rights which are very, very basic and fundamental. If you just remove fundamental rights, and your democratic state will become a police state, an authoritarian state. It constitutes very important constituent. It constitutes a very important portion. It constitutes very important portion of any democracy. Any democracy. You cannot think of democracy without fundamental rights having been conferred on its people. Clear? So you have human rights. Human rights, scope of human rights is very broad. Then you have fundamental rights, which are more specific. They're more specific and very basic in nature. Again, most of the cases it is guaranteed by the constitution or law, something like this. But in Indian context, you can say fundamental rights. Fundamental rights are not the rights which have been given to us by the parliament. Fundamental rights have been guaranteed by the constitution. Okay? Now have a look on it. So you have a civilized society, stable and peaceful coexistence, rights and duties enforcement. First of all, you need to I discussed rights. You exercise claim over something. You claim over something, some kind of entitlement, but by virtue of some disposition, legitimate disposition, there has to be some justifiable ground wherefrom you exercise claim over something that is known as right. Then I discussed human right. Scope is very broad. Those rights which are inalienable, very basic, inalienable, indivisible, which is associated with every human being, irrespective of his rights, which are recognized for every individual on this planet, irrespective of caste, class, region, religion, ethnicity, nationality, whatever you say. Human rights are available to all. Then we discuss fundamental rights. That component of human rights, which is very basic and fundamental, extremely essential for multidimensional growth and development of any individual. Clear? Now come to civilized society. What is significance? How to establish the link? Whenever think of any civilized society, whenever we think of any civilized society, what kind of society we think of? When we think of civilized society, we think of a society which is stable, which is very much peaceful, society wherein people have evolved and they have learned to live together. It is characterized by peaceful coexistence, and this is possible only when people have learned to enjoy their rights, and they also respect the similar rights of others. It means it is impossible to think of a civilized society without some kind of collective acknowledgement of rights, duties, and obligations on the part of individuals and groups. So when we think of civilized society, we think of a stable and peaceful society. And this kind of society is possible only when individuals enjoy their rights and they also respect the similar rights of others. And if individuals are not only individuals, groups, and communities, they are not only concerned with their rights, they're cognizant of their duties. It means on the one hand, rights are very much clear. They exercise claim over something, entitlement by virtue of some disposition. At the same time, they also acknowledge the claim of others on their life and resources or their property, by virtue of some disposition. So that is known as duties. So exercise claim over something, when you exercise claim over something, some kind of entitlement, it is known as rights. And when you acknowledge the similar claims of others on your resources, on your life and property, in one or other ways, that is known as duties. The society, to be stable, individuals and groups, they have to be right conscious as well as duty conscious. That you enjoy your rights, you are aware of your rights, you know your rights, and you enjoy those rights. At the same time, you acknowledge and you respect the rights of others. In this way, a peaceful society and stable society can be conceived of. It is about mutual appreciation, acknowledgement, and respect, mutual respect for the rights of one another. If a society is duty conscious, there is another way to look at the things. So when we think of a stable or civilized society, we think of a society where people are right conscious as well as duty conscious. So in this way, the society chances are restricted of any conflict and friction. I don't mean to say that no conflict friction take place, but chances are big. If the rights and duties are well defined and it is also exercised and is practiced by the society. Civilized society and rights and duties. These are integrally connected to one another. Otherwise, individuals differ from one another. No person are similar. No two persons are similar to each other. Not in terms of thumb impression, other things. Your psychological state of being, your mental, emotional state of being, your perception of life, your likes, dislikes, preferences, you differ from one another. Heterogeneity is more prolific a principle. Heterogeneity is the principle which is seen prolifically expressed than homogeneity. Heterogeneity is the principle which is seen everywhere in the life. Different kinds of flowers, different kind of fruits, different kind of vegetables, different kind of crops, different kind of ecological conditions. Heterogeneity is more common than homogeneity. Same is applicable to human beings, individuals, groups, and communities that differ from one another. What is that which keep them together in a society? It is well defined rights, duties, obligations, and their sustained enforcement. It is what keep the entire society, what keeps the society intact. We may differ from one another. I may like and may not like certain things about you, but just as I am capable of expressing my rights, and similarly I have to acknowledge that you are also capable of expressing your rights under some kind of law. Yes, if you cross the boundary, then only action can be taken. Rights and duty. Without defining and enforcing rights and duties, you cannot think of a society without friction. You cannot think of a peaceful society. You cannot think of a civilized society. And if a society can be, if any society, in any society, if you find that individuals, groups, and communities, they are very much duty conscious. A duty conscious society, in a duty conscious society, rights do not hold much significance. Why? Because I, you, and others, if all of us are duty conscious, it means we'll keep, we exercise or we acknowledge the claim of others over, we acknowledge the claim of others on our resources. If most of the persons are duty conscious, the question of rights will not arise. एक डॉक्टर जो है, डॉक्टर डॉक्टर बहुत ज़्यादा ड्यूटी कॉन्शियस अगर हैं, आपके कहने से कोई मतलब नहीं है, वो आपका ट्रीटमेंट बेस्ट पॉसिबल तरीके से हो सकता है, अपनी पूरी सक्षमता के अनुसार वो करते हैं। ठीक है, तो वो उसे अपना कर्तव्य समझते हैं। वो समझते हैं कि आपका ये क्लेम है हमारे ऊपर, मैं डॉक्टर हूँ, ठीक है, मैं डॉक्टर हूँ, मुझे सरकार सैलरी देती है, या मैं प्राइवेट प्रैक्टिस अगर हूँ, कुछ भी आप उसकी फीस देते हैं, ये मेरी ड्यूटी है कि बेस्ट पॉसिबल ट्रीटमेंट जो आपके लिए हो, मैं सुनिश्चित, मैं एक टीचर हूँ, मैं एक टीचर हूँ, तो ये मेरी जिम्मेदारी है कि आपको पढ़ाऊँ बेस्ट तरीके से, जो मुझे आता है, जितना आता है वैसे पढ़ाऊँ। अगर एक टीचर, एक डॉक्टर, ठीक है, कोई पॉलिटिशियन, कोई ब्यूरोक्रेट, कोई टेक्नोक्रेट, हर कोई अपने ड्यूटी पे अगर बहुत ज़्यादा, ड्यूटी को लेकर बहुत ज़्यादा कॉन्शियस है, तो दूसरी तरफ किसी व्यक्ति को अपने राइट्स के बारे में सोचना पड़ेगी नहीं। तो ड्यूटी कॉन्शियस सोसाइटी स्टैंड्स ऑन ए हायर मोरल पेडेस्टल कंपेयर टू राइट कॉन्शियस सोसाइटी। राइट कॉन्शियस सोसाइटी में आप क्लेम करते हैं, इसलिए दूसरे जो है वो अपनी जगह पे रहेंगे। आप भी अपना क्लेम करते हैं, वो भी क्लेम करते हैं, ठीक है, यू क्लेम, यू एक्साइज योर क्लेम ओवर समथिंग, बट इन ड्यूटी कॉन्शियस सोसाइटी यू एक्नॉलेज द क्लेम ऑफ अदर्स। अगर अधिकतर लोग ऐसे अगर होंगे तो सोसाइटी कैसी होगी? रामायण और महाभारत में आपने देखा होगा, रामायण और महाभारत में सोसाइटी कैसी है? उस वक्त सोसाइटी ड्यूटी कॉन्शियस है, राइट कॉन्शियस, ड्यूटी कॉन्शियस है। अगर सोसाइटी में हर एक व्यक्ति ड्यूटी कॉन्शियस अगर है, तो राइट्स के मामले ज़्यादा उठेंगे ही नहीं। आपने अधिकार की बात तभी करते हैं जब कहीं ना कहीं आपको लगता है कि आपके साथ अन्याय हो रहा है, जो आपका इंटाइटलमेंट है, जो आपका क्लेम है, जेन्युइन क्लेम, अगर वो आप एक्सरसाइज नहीं कर पा रहे हैं, तभी आप ऐसे क्वेश्चन रेज कर। लेकिन हर व्यक्ति आसपास अगर ड्यूटी कॉन्शियस है, तो आपको कुछ क्लेम करने की नौबत ही नहीं आएगी। पॉइंट क्लियर? तो ड्यूटी कॉन्शियस सोसाइटी इज जनरली कैरेक्टराइज्ड बाय लिस्ट ऑफ फ्रिक्शन। फ्रिक्शन, कॉन्फ्लिक्ट तो छोटी चीज हटाइए उसको। दे लिव वेरी पीसफुली एंड दे लिव, दे हैव ए वेरी हाई स्टैंडर्ड ऑफ लिविंग। वहाँ फ्रिक्शन की गुंजाइश बहुत कम हो। तो ड्यूटी कॉन्शियस सोसाइटी एंड राइट कॉन्शियस। लेकिन अब उतनी महानता हम लोग अब नहीं सोचते कि हर जगह ऐसा नहीं होगा। राइट्स भी है और ड्यूटीज भी। आज अनफॉर्चुनेटली हमारी सोसाइटी में क्या है, हमारी सोसाइटी में अधिकतर लोग राइट कॉन्शियस, वी कीप टॉकिंग अबाउट आवर राइट्स एंड वी आर नॉट सो मच ड्यूटी कॉन्शियस। दैट्स व्हाई सो मच कॉन्फ्लिक्ट इन सोसाइटी हैज टू बी। हर कोई ये सोचता है कि मैं क्या दावा कर सकता हूँ, क्या कुछ ले सकता हूँ। ये नहीं सोचता है कि दूसरों का क्या दावा मुझ पर है। डॉक्टर्स ये नहीं सोचते हैं कि सरकार तनख्वाह दे रही है, गवर्नमेंट हॉस्पिटल में जहाँ भी वो काम कर रहे हैं, तो वो ये नहीं सोच रहे हैं कि लोगों का उनके ऊपर क्लेम है, ना भरोसा है लोगों का, इस पे ध्यान कम है। और इस पे ध्यान अगर ज़्यादा है, क्या मेरा क्लेम है, मतलब मैं क्या योगदान कर सकता हूँ, दूसरों के लिए क्या कर सकता हूँ, मुझे क्या मिल सकता है, इंपॉर्टेंट है। सोसाइटी जो काइंड ऑफ लिविंग होगी, मोरली डेफिशिएंट सोसाइटी। इसलिए बच्चों को राइट्स के साथ साथ बच्चों को ड्यूटी कॉन्शियस बनाना बहुत, आई एंजॉय दिस राइट टू दैट, बट यू हैव ए ड्यूटी। ठीक है, एक सन, एक डॉटर के तौर पर तुम्हारी ड्यूटी, हस्बैंड और वाइफ के रूप में तुम्हारी, एक सिटीजन के तौर पर तुम्हारी, एक इंसान के तौर पर तुम्हारी ड्यूटी। आप ड्यूटी के बारे में जब ज़्यादा सोचते हैं, आप हमेशा व्हाट कैन आई डू फॉर यू, मैं क्या कर सकता हूँ, तो एक अलग ही क्लास हो गया। एक तो लोग इस टाइप हो जाए किसी समाज में, वही स्वर्ग है। ठीक है, तो civilized society, stable and peaceful coexistence, rights and duties, enforcement, then human rights and fundamental rights. Human rights are very broad in range, it's very, very broad and very wide in scope. Okay, human rights, but fundamental rights constitute a big portion in human rights, acknowledged or recognized by law, constitution. Those human rights, those human rights which are very basic, and very fundamental for the moral, physical, and intellectual growth of any individual. So, human rights and fundamental rights are guaranteed by the Constitution. In the context of India, we say that fundamental rights have been guaranteed by the Constitution. Supreme Court is the guardian of the Constitution and protector of our fundamental rights as well. Then fundamental rights, legal rights, and constitutional rights. Simple point. Fundamental rights are those which have been conferred on us directly by the Constitution. Directly by the Constitution. Whereas legal rights are those rights. Legal rights are those rights which have been conferred on us by the Parliament. Conferred on us by the Parliament. What I mean to say? Through the enactment of law. Parliament has enacted a law, has conferred on us certain rights. These rights are known as legal rights. Constitutional rights. Constitutional rights are those rights which emanate from the Constitution but which are not the part of which are not the part of fundamental right. They are not the part of part 3 of the Constitution. Point clear? So constitutional rights are those rights which have been conferred on us through one or the provisions of the Constitution, but not the fundamental rights. Only part 3, which deals with fundamental rights. Here the rights which are available, these rights have been conferred to us directly by the Constitution. And second thing, these are directly enforceable in the court of law. In the case of violation of fundamental rights, you can move Supreme Court directly. You can avail of the remedies as mentioned in the Constitution. But constitutional rights are the rights which are mentioned in one of the provisions of the Constitution beyond Part 3. So they are constitutional rights, they are not fundamental rights. So their enforceability is not so easy. Fundamental rights are easily enforceable. In case of violation of fundamental rights, you can move Supreme Court as well as High Court. Fundamental rights, legal rights, and constitutional rights. Then fundamental rights and Indian Constitution. So fundamental rights in the Part 3 of the Indian Constitution. Part 3 of Indian Constitution guarantees fundamental rights to its citizens. Fundamental rights, as I discussed, fundamental rights are very basic and so fundamental that in the absence of fundamental rights, we cannot think of growth and development of any multi-dimensional growth and development of any individual. And these are easily enforceable in court of law. In other rights, you cannot move Supreme Court directly, but in the case of violation of fundamental rights, you can move Supreme Court directly and you can seek remedy. Fundamental rights and the is constitutional guarantee. So there is a guarantee given by the Constitution, then easy enforceability, I have discussed. Then you have stability. Fundamental rights provide stability. A kind of state strikes a fine balance between the authority of state on the one hand, and then freedom of people on the other. So when we think of a stable polity, we cannot think of a stable and sustainable polity unless the authority of the state on the one hand and rights of the people on the other hand, it has been properly balanced. If you confer too much of authority on the state, it will trample over the freedom and rights of the people. If you confer too much of rights on people, then they will not allow state to function. It's difficult. That too much of rights will cripple the authority of the state. For every action of the administration, they'll keep moving, they'll move Supreme Court and High Court, they'll keep dragging, the government and administration to the court of law. So in every society and polity, balance is required to be struck between the two. So you have, it provides fundamental rights, provide stability. It is the point. Fundamental rights are in the nature of a protective shield. 140 crore people, and this is the protective shield. It is here that the authority of the state comes to an end. The state can exercise authority only to the extent it does not encroach upon these rights conferred by the Constitution on us. So there is a balance. Fundamental rights are in the nature of shackling the body of the state. Shackling, it means shackling in the sense is not in the that negative sense. It means as long as you are exercising authority for the purpose authority has been conferred on you. You are working for growth and development and security, providing a conducive environment, where the people could enjoy their life as we think of in a welfare state. As long as you are exercising authority in furtherance of goals and objectives as enshrined in the Constitution, there is no problem. The moment it is found that institutions or the functionaries therein, they start exercising authority beyond that limit for personal aggrandizement to the detriment of the freedom and rights of people, then the things become active. So for stability, fundamental rights essentially it ensures Fundamental rights ensure that your state remains a democratic state. It is not allowed to become a police state or an authoritarian state. Next is stability. The negative obligation for state is a negative. Fundamental rights are in the nature of creating a negative obligation for state. It restricts his authority. That when it comes to frame policies or implement the policies, or when it comes to enact law, to pass any order, or to pass any order or any command, any bylaws, administrative action, all such things have to ensure that they do not touch upon the fundamental. They do not touch fundamental rights. So these are negative obligation for the state. Next is not absolute in character. Fundamental rights are not absolute in character. Fundamental rights are relative in nature. So it means, and it's quite simple. You cannot think of a stable society where people enjoy fundamental rights without any limitation. If an individual is allowed to exercise his right without any limitation or restriction, he is much likely to encroach upon the similar rights of others, and that will lead to conflict and friction. It means a stable and peaceful coexistence is possible only when we exercise our rights reasonably, we exercise our rights sensibly. Your right to swing umbrella ends where the nose of others enter. आप अम्ब्रेला छाता खूब घुमाओ, लेकिन आपको इस बात का ध्यान रखना है कि आप जो डांस कर रहे हो, राज कपूर बन रहे हो, तो आप दूसरे की नाक को चोट नहीं पहुंचा सकते। ठीक है, पुरानी बातें हैं, कहावत है ऐसी। ठीक है कि आप योर राइट टू स्विंग अम्ब्रेला एंड्स वेयर द नोज ऑफ अदर्स एंटर। कोई आपके आसपास नहीं है, आसमान में देखिए बारिश है, छाता घुमाइए, कोई प्रॉब्लम नहीं है, लेकिन अगर आपके आगे और पीछे लोग चल रहे हैं पार्क में, तो आपको इस बात का ध्यान रखना पड़ेगा। यू डोंट हैव अनलिमिटेड राइट्स, यू हैव ओनली लिमिटेड राइट्स। द गिवन सिचुएशन, circumstances, you need to ensure that your exercise of rights does not lead to violation of the similar rights of others. You have to be sensible. You have to exercise your right, your right to freedom and liberty sensibly, because you are not alone. You are a part of society. And acknowledgement of our collective interests, giving preference to collective interest over narrow individual interest, constitutes the very foundation of any democracy. That's clear. So they are not absolute in character. So you enjoy fundamental right subject to certain restrictions. It may be public order or morality or decency, sovereignty and security of the country, unity and integrity of the country. A number of restrictions are there on fundamental rights. But remember, such restrictions have to be reasonable. Because the government can amend fundamental rights, government can add new restrictions. But whenever any restriction is imposed on fundamental rights, that restriction has to be seen has to be seen in consonance with the objective it aims at achieving. So the government can restrict fundamental rights, but the government, if it is challenged, government will have to prove in the court of law that restriction was reasonable, and this restriction basically aims at accomplishing, a justifiable objective. So, what is the purpose of restriction, and what is the degree of restriction? This can be subjected to judicial scrutiny. In this way, balance is struck. Again, not obligation, not absolute in character. Next, we have Article 15, 16, 19, 29, 30. These fundamental rights are available only to citizens. Article 15, prohibition of discrimination, in all matters. Article 16, equality of opportunity in the matters of public employment. Article 19, right to freedom, six freedom, याद करो, कुछ पढ़े होगे थोड़ा बहुत, ठीक। Article 19, freedom of speech and expression, freedom to assemble, freedom to form association for the territory of India, ये सब है ना, right to follow any profession, and freedom to follow any profession, occupation, and to settle down anywhere within the territory of India. So Article 19, Article 29 and 30, your cultural and educational rights. Okay, so these rights are available only to citizens, and other rights are available to citizens as well as foreigners on Indian soil. They also enjoy this freedom, equality before law, equal protection of all laws, right to life and personal liberty, protection in case of conviction for offenses, religious rights. Getting a point? Right to religious freedom. These are the rights which are available to all, and these fundamental rights are available only to the citizens of this country. And then fundamental rights are not transcendental. It can be amended and can be suspended. Fundamental rights are not transcendental in nature. Not transcendental in nature. that they are so sacrosanct that they cannot be amended. It's not like that. Fundamental rights can be amended like any other provision in the Constitution. Fundamental rights too can be amended. Yeah, and in the case of national emergency, your fundamental rights, in case of emergency, fundamental rights can be suspended, but your fundamental rights under Article 20 and 21 cannot be suspended even during proclamation of emergency. Here, they are not transcendental and can be amended and suspended. Fundamental rights can be amended like any other law, any other provision of the Constitution. It can be amended provided it does not violate the basic structure of the Constitution. When we talk about basic structure of the Constitution, talk about those fundamental principles, values, which constitute the very foundation of our polity, very foundation of our Constitution. Those things which are mentioned in the preamble, although basic structure has not been clearly defined by the Supreme Court, but inference can be drawn from the various judgments of the Supreme Court. You talk about sovereignty of this country, independence of judiciary, power of judicial review. Getting a point? And federal polity, then all such things put together, it constitute, and apart from others, it constitute the basic structure of the Constitution. So up to this point is clear. And one more thing, it's posited mainly against the state. You enjoy fundamental rights. You enjoy fundamental rights against the state. You enjoy fundamental rights mainly against the state. But there are some fundamental rights which you enjoy. There are some fundamental rights which you enjoy against private, individual, citizen, and institution as well. Are you getting a point? You enjoy fundamental rights against state. But there are certain fundamental rights which you enjoy against state as well as private, individual, citizen, or institution. As for example, uh, Article 17, which provides for abolition of untouchability. Untouchability. This is a fundamental right which you enjoy against the state, okay, and against the private individual as well. Article 17. Similarly, uh, Article 21, right to life and personal liberty. This is the fundamental right that you enjoy. This is the fundamental right that you enjoy against the state as well as private citizen. Okay, so another fundamental rights you know very well. So mainly you enjoy against the state, but some fundamental rights you enjoy against the state as well as a private citizen or individual. Fine. Then you should also know about Article 20, Article 12. That when we talk about fundamental rights, you enjoy fundamental rights against state. You enjoy fundamental rights against state. Most of the fundamental rights you enjoy against the state. Then the question arises, what constitutes the state? Definition of state should be very much clear because it will have implications for legal proceedings. Because if something does not enjoy the status of a state, then you cannot move against that entity for violation of fundamental rights. You will have to move under some other legal provisions. So it is necessary to understand what constitutes the state. So state, Article 12 defines that state means union and state executive and legislature. State means union and state executive. Union, state executive, legislature, local government and authorities, and sometimes private entities as well. If it is found that any private entity under some kind of contractual arrangement is working with any public authority, any public institution, governmental institution as an agent, then it can also be treated as a state. In the limited sense, it can be treated as a state, and therefore, against it can move the court of law if there is violation of any fundamental right because of their action or inaction. Here, this is Article 12, Union and State Executive and Union State Legislature. So you have Lok Sabha or Raj Sabha for that, whether Vidhan Sabha in the state and Legislative Council, then local government, Panchayati Raj institutions, or for that matter, municipal corporation, municipalities, and other authorities. Then you have state authorities and private entities as working as an agent. Yeah, so this is the definition of state. And then Article 13 is equally important because Article 13 clearly states that if any pre-constitutional law, any law existing prior to the commencement of the Constitution, and thereafter any law enacted by the Parliament, if any such law is found to be inconsistent with fundamental rights, if any such law is found to be inconsistent with fundamental rights, then the extent to which it is inconsistent or it is in derogation of the fundamental rights, it can be declared as void. It can be declared as the extent to which it is inconsistent, the extent to which it is derogatory, it is in derogation of the part 3 of the constitution, the fundamental rights. So to that extent it can be declared as null and void. So article 13 in a way empowers the judiciary. Article 13 is the source of power of judicial review. It empowers the court to examine such law, and not only law, any law enacted by the union or the state legislature, or any policy of the government, or any bylaws, any order. Getting a point? Because any bylaws or any order or rules, regulations, or for any administrative action, not only law, even administrative action come within the bounds of power of judicial review. If any such law, any administrative action, any order, any command, any bylaws are found to be inconsistent or violative of fundamental rights, to that extent it can be declared as void. Is clear? This is the power of judicial review. Power of judicial review has not been defined explicitly in our constitution. Yeah, it is something that you need to draw. As for example, like in Article 13, Article 13, Article 13 is the source of power of judicial review because it clearly says that if there is any kind of violation of fundamental rights, then such laws and administrative action can be declared as void. Similarly, there are other articles in the Constitution. These articles also directly or indirectly it empowers the judiciary to declare such laws or administrative action as void if it is void, is found to be violative of fundamental rights. As for example, if you take Article 131 to 136, 31 to 130, this is something which is related to Article 131 to 136 relates to original and appellate jurisdiction of the Supreme Court. Okay, under this article, Supreme Court exercises power authority to take cognizance of any case at the first instance, and appellate jurisdiction means that Supreme Court can hear appeal emanating from the judgment of the High Courts. So appellate jurisdiction and original jurisdiction here, through this jurisdiction, they can examine the law or any administrative action and can declare them unconstitutional, can declare them null and void if it is found to be violative of fundamental rights. Article 246 deals with division of power between central government and state government. It is related to federal distribution of power. If any kind of dispute arises here also, it can be examined by the Supreme Court and can apply the correctives that what belongs to state government and what belongs to the union government. These are the source of power of judicial review. It means these articles in a way facilitates intervention of Supreme Court to decide the constitutionality of things. Article 2 to 6 is related to writ jurisdiction of High Court. So High Court, just like Article 32 here, Article 26 under this is related to writ jurisdiction of the High Court, wherein the High Court can issue any writ, habeas corpus, mandamus, quo warranto. So these writs can be or prohibition. It can be issued by the High Court in case of violation of fundamental rights and legal rights. Here, writ jurisdiction of High Court is wider than the writ jurisdiction of Supreme Court because High Court can issue writs in case of violation of fundamental rights as well as legal rights. Here, under Article 32, similar jurisdiction is there with the Supreme Court. 32, writ jurisdiction of Supreme Court, it can issue writs in case of violation of fundamental rights. Remember, Supreme Court can issue writs in the case of violation of fundamental rights only, not legal rights. And High Court can issue writs in case of violation of fundamental rights as well as legal rights. So judicial review here is wider. Power of judicial review of High Court is wider in this respect compared to Supreme Court. And then you have Article 143. This is related to advisory jurisdiction of the Supreme Court, under which the Supreme Court gives advice to the President of India. The President of India can refer any question of constitutional importance, having implications for futuristic implications for the policy decisions to be taken by the government. Any question of constitutional importance like this can be referred to the Supreme Court. And the Supreme Court gives advice here more as a friend, philosopher, and guide of the government rather than in judicial capacity. And here also, the Supreme Court can review the things, can apply correctives. Supreme Court can suggest what is constitutional and what is not. So, what I mean to say, this is the framework of judicial review. Judicial review, legal framework of judicial review. Judicial review is not something which has been defined explicitly under any article, any particular law having a specific, the provisions providing for intervention of the court. The power of judicial review emanates from different articles of the Constitution. These are the main articles, which empowers the Supreme Court or which facilitates intervention of Supreme Court to deal with one or other subject matters of constitutional importance, wherever the review has to be done, whether things are constitutional or not. Unclear? So this is fundamental rights. I discuss what is the meaning of rights and different types of rights. Then I discussed human rights, fundamental rights, and human rights and fundamental rights. The difference between the two. Then human rights, and then in the context of civilized society, we discussed rights and duties. We cannot think of a civilized society without a well-defined construct, a matrix of rights, obligations, duties, which is capable of restricting the possibility of friction and conflict and capable of facilitating a smooth flow of life. So, and which can bring some kind of predictability and certainty in the behavior of the people towards one another. This is regarding civilized society. Then you have fundamental rights, legal rights, constitutional rights. I have discussed fundamental rights and Indian Constitution. I have discussed these are the important things associated with fundamental rights. Then I discussed Article 12 and Article 13. Against Article 12 and 13, we have to examine fundamental rights. Here, you enjoy rights against state, and state means this, and your fundamental rights is something. Fundamental rights hold a lot of significance. In the absence of fundamental rights, a state cannot be called a democratic state. And then this is the power of judicial review, that is clearly mentioned in Article 13, that no law, any law prior to the commencement of the Constitution and after that cannot survive, cannot survive if it is violative of fundamental rights, or it is in derogation of fundamental rights or inconsistent with fundamental rights. This is power of judicial, and I discussed power of judicial review in this context. I said that power of judicial review is not explicitly mentioned in a particular law, a particular article. It derives from different articles of the Constitution, which empower the judiciary to examine any law, as well as law or the policy of the government, direction of the government, any instruction in law or bylaws, rules, regulations, as well as administrative action of the state, to examine whether or not it is consistent with fundamental rights. So the extent to which it is found to be violative of fundamental rights, it can be declared as null and void. Up to this point is clear. Fundamental rights. You have the doctrine of severability and doctrine of eclipse. The A.K. Gopalan case, Supreme Court explained so nicely. Doctrine of severability. Severe means to cut off. Alag karna. Doctrine of severability says that it states that if any law is violative of fundamental rights, or it is in derogation of fundamental rights, then only that portion which is inconsistent with fundamental rights can be done away with. It is not necessary to declare the entire law as unconstitutional. Are you getting a point? Doctrine of severability suggests that if any provision of the law, in a law we have number of provisions, if any provision or number of provisions are found to be inconsistent with fundamental rights, or are found to be derogation of fundamental rights, to that much extent only, we can declare, Supreme Court can declare it void. That portion can be cut off and the rest of the portions will remain valid. Okay, what is the idea behind it? Idea is like, why to declare entire law as unconstitutional? There can be some technical or other problem in one of the provisions of the Constitution. Okay, you just need to remove that, and if the rest of the laws are good, they are in consistency with fundamental rights, then it should be allowed to be enforced. In this way, you can save a lot of time. Unnecessarily, you should not get burden for the state. Clear? But there are certain limitations. If the portion which is found to be inconsistent with fundamental rights, if that portion is so much important that it constitutes the very soul of the law, If this is cut off, then and after that, what remains? It is so less. Then in that case, entire law has to be declared as unconstitutional. If the portion where you have problem, that portion is so intricately mixed, placed with other provisions of the constitution, but good or bad provisions are intricately mixed, where it is not possible to bring out a component which is unconstitutional. So in that case, entire law has to be declared as unconstitutional. Clear? So these are certain limitations of doctrine of severability. एकदम सिंपल, इतने ज़्यादा. एक आलू देखे हो, आलू आलू घर पे कभी सब्जी उब्जी बनाए हो, कुछ काटे हो, आलू में कभी होता है ना ब्लैक स्पॉट होता है, तो तुम क्या करते हो? कोई भी कुशल गृहिणी को देखोगे, कोई भी, मतलब ऐसा तुम शायद ही किसी को देखोगे आलू में कोई ब्लैक स्पॉट है, उसने पूरा आलू ही फेंक दिया. अगर फेंक दिया तो मतलब क्या बोले, अब छोड़ो. तो वो आलू जो ब्लैक स्पॉट है उसको कट कर देते हैं. एकदम बिल्कुल सही आ गया, उसको बना लो. लेकिन कभी कभी क्या होता है कि तुम ब्लैक स्पॉट इतना गहरा होगा, उसको कट करो तो खराब पोर्शन आलू का जो है वो फिर भी ब्लैक है, फिर और कट करते हो फिर ब्लैक है, फिर और कट करते हो फिर भी ब्लैक है. तो लास्ट में जब इतना बचा तो क्या करोगे, वही फेंक दो. समझ गए? यही है डॉक्ट्रिन ऑफ सिमिलरिटी. मतलब कि एक लॉ है, उसमें एग्जाम्पल समझो 10 प्रोविजंस हैं, एक या दो उसमें प्रॉब्लम कहीं पे है, तुम उसको कट ऑफ कर दिए तो बाकी अप्रेबल है. लेकिन एक दो जो कट किए, तब फिर देखिए तीसरे में प्रॉब्लम है, चौथे में प्रॉब्लम. अगर बचा 10 में से 7-8 में प्रॉब्लम ही है, तो रिमेनिंग पोर्शन से तो होगा नहीं है. वो लॉ का पर्पज ही, या फिर जो पोर्शन जिसमें प्रॉब्लम है वो सबके साथ ऐसा मिला हुआ है कि तुम उसको बाहर निकाल नहीं सकते, नहीं निकाल सकते. गुड है, बैड बैड प्रोविजंस को इस ढंग से मिक्स कर दिया गया है, मतलब लॉ इस ढंग से ड्राफ्ट किया गया, उसमें पॉसिबल ही नहीं है. ठीक है. सो इन दैट केस ऑल्सो इंटायर लॉ हैज टू डिक्लेयर्ड एज अनकॉन्स्टिट्यूशनल. यही है डॉक्ट्रिन ऑफ सिविलिबिलिटी. जिस पोर्शन में प्रॉब्लम है सिर्फ उसको कट ऑफ करो. नेक्स्ट है डॉक्ट्रिन ऑफ एक्लिप्स. कुछ ग्रहण लग जाना. ठीक है. दिस डॉक्ट्रिन इज एप्लीकेबल regarding those laws which were in force prior to the commencement of the constitution. It suggests that if any law existing before the commencement of the constitution is found to be inconsistent with fundamental rights, so to that extent that law will become inoperable, it will be void, but it will not be a dead letter. It will remain only in dormant state. मतलब संविधान जब लागू हुआ उसके पहले जो कानून थे, कोई कानून उसके पहले जो भी कानून कमिटमेंट ऑफ द कॉन्स्टिट्यूशन के पहले जो है, प्रायर टू द कमिटमेंट ऑफ द कॉन्स्टिट्यूशन, अगर वो कानून सीधे सीधे फंडामेंटल राइट्स जो बाद में लागू हुआ, कॉन्स्टिट्यूशन लागू हुआ, फंडामेंटल राइट्स भी इन्फोर्स हो गए, उसके साथ अगर इनकंसिस्टेंट अगर है, तो जहाँ तक इनकंसिस्टेंट है वहाँ तक वो जो है वो मतलब वॉइड हो जाएगा, वो एप्लीकेबल नहीं होगा. लेकिन वो डेड नहीं होगा, वो डोमेंट स्टेट में होगा. क्योंकि हो सकता है कि फ्यूचर में फंडामेंटल राइट्स में अगर अमेंडमेंट हो, तो जो कॉन्ट्रडिक्शन है फंडामेंटल राइट्स और लॉ के बीच में वो खत्म हो जाए, तो फिर दैट लॉ विल बी एज गुड एज एनी अदर लॉ. तो केवल उसके ऊपर ग्रहण लगेगा, वो खत्म नहीं होगा. डॉक्ट्रिन ऑफ एक्लिप्स. तो बीकाजी वर्सेस स्टेट ऑफ एमपी इस उसमें डॉक्ट्रिन ऑफ एक्लिप्स. फिर से एक बार बता दे कि डॉक्ट्रिन ऑफ एक्लिप्स सजेस्ट दैट प्रायर टू द कमेंसमेंट ऑफ कॉन्स्टिट्यूशन, any existing law, if it is found that any law prior to the commencement of the constitution is inconsistent with fundamental rights, then the extent to which it is inconsistent, it will be void. It will be void, but it will not be a dead letter. It will not be operable, but it will not be a dead letter. It will be eclipsed. It means in future, if any kind of amendment takes place, okay, and this contradiction with fundamental rights and this contradiction between the fundamental rights and this provision of this law is done away with, so in that case it will be operable. तो ये सिर्फ ग्रहण लगेगा, ये खत्म नहीं होगा. Then you have categories of fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, and right to constitutional remedies. ये आने वाले डिस्कशन का रोड मैप है. We will begin from here. Right to equality, right, article 15, 16, नहीं, right to equality 14 चालू होगा, 14, 15, 17, 18. ठीक है. 14, 15, 16, 17, 18 इसको करेक्ट कर देते हैं. Article 14, 15, 16, 17, 18, 19, 20, 21, 22, तो ये हो गया पहला ग्रुप है राइट टू इक्वालिटी, फिर है राइट टू फ्रीडम 19 से 22, राइट अगेंस्ट एक्सप्लॉइटेशन 23 24, राइट टू फ्रीडम ऑफ रिलीजियन 25 26 27 28, कल्चरल एंड एजुकेशनल राइट्स 29 30, राइट टू प्रॉपर्टी 31, राइट टू प्रॉपर्टी 31, उसका राइट टू कॉन्स्टिट्यूशनल रेमेडीज आर्टिकल 32, 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1978 डिलीटेड इट, now it is a legal right under article 300A. So right to property used to be a fundamental right, but it is no more a fundamental right. इसको हम लोग separately discuss करेंगे. इसको 44th constitutional amendment से इसको delete कर दिया गया यहाँ से. It is no more a portion of fundamental right. ये सिर्फ दिखाने के लिए था. ठीक है? तो next lecture में हम डिस्कस करेंगे right to equality. ठीक है. Thank you.